It's great to be back on the program. Here we are in mid-August, August 19th, and summer is starting to wind down. Summer camps are ending for some of us with kids, myself included, and school years are just around the corner. So it's a time of transition. I hope that those of you who haven't caught a few days of summer break are in position to take a moment to recharge. And in the interim, let us walk you through some material today that we think will be informative as always. If Kathy, you go to the next slide, please, I'll touch on the agenda. Right after I'm done here, Ariana Dudowitz, who's with us from our Rochester office and who's been on the program twice before, is going to be talking about a new private health data tracking system that the administration is interested in moving forward. There are a lot of details yet to be worked out, and Ariana is going to give us the latest. Gregory Katz, my colleague from the New York City office, will be thereafter, and he's back after being on the program just 2 weeks ago. So Greg, thank you. And this time, Greg will be talking about a private equity relating order from the administration and what plan fiduciaries need to know. And then Michelle Piasecki is with us from the Albany office. Michelle has experience in a variety of areas of law, and in particular energy, and is looking to bring us up to speed on a new standard that is going to be enforceable as of January 1 of 26. And so we want to make sure that all of you were up to speed. Let me, without further ado, bring Ariana on. As I mentioned, she is from our Rochester office. She has an interesting and varied set of experiences that precede arriving at Bond, including working with the Puerto Rico Recovery Assistance Legal Clinic while she was a student attorney. She's actively involved in our in our cybersecurity and data privacy practice. And what she'll be speaking about, to be clear, is an overlay of cybersecurity and data privacy with healthcare. Ariana, please go ahead and bring us up to speed. We're excited to learn from you, and thank you for coming back onto the program.
Thank you for introducing me, Gabe. Hello, everyone. My name is Ariana Dudowitz, and I'm here to discuss the new announcement by the Trump administration regarding the private health data tracking system. Next slide, please. So on July 30th, 2025, the Trump administration announced a new program in partnership with major tech companies like OpenAI and Google to allow Americans to share personal health data and medical records into a private health tracking system and across multiple apps. This system would be overseen by the federal government through the oversight of the Centers for Medicare and Medicaid Services, who is currently run by Dr. Mehmet Oz. Over 60 major companies such as Amazon, Google, and OpenAI have agreed to share patient data into the system. Next slide, please. Additionally, this is seen as, I quote, the killing of the clipboard. It is meant to create a comprehensive one or like multiple apps to get a comprehensive view of health records and to monitor wellness, offering a complete picture of the patient's health, those who would like to participate in the program. The initiative plans to focus on diabetes and weight management at first and hopefully expand. The system is anticipated to be released during the first quarter of 2026. And back in 2018, the Trump administration made a similar proposal, but the plans did not come into fruition. But it was a unified app that would allow patients to enter healthcare information. Next slide, please. The key features of this private health tracking system is it is based on an opt-in model where patients must consent to sharing their data. It uses conversational AI tools for symptom tracking and health decisions that are personalized based on the patient's data. And they see this as time goes on, you get a more clear picture of the patient and their needs through utilizing these systems. They plan to use digital tools such as QR codes and mobile apps for check-ins and medication tracking to streamline all of the information. Next slide, please. Also, I meant to add that they want to, this system is meant to clear the gaps in the tech side of the healthcare systems. Currently, it is not as tech as the rest of the fields, such as the educational field. So they want to mend the gap with that. The data privacy concerns is that there are risk of the personal health data by patients utilizing the apps being accessed or misused. There are concerns with informed consent and whether the tracking system would be utilized for the reasons disclosed. There is skepticism associated with the security of data storage, and there's HIPAA compliance issues and concerns about whether third-party apps would meet the federal privacy standards. So regarding the security of data storage, the Trump administration announced that it would not be one site that would oversee it. It would be multiple apps that enter the patient data, but there are still risks of data privacy and like breaches that are associated with having patient data. Next slide, please. So the implications of this is the potential benefits is it's easier to access medical records and health records. There's a better understanding and comprehensive view of the patient's health, and the system is seen as a technology upgrade bringing healthcare into the digital age. The potential risks are data breaches, misuse of personal health information and other data, and then the regulatory gaps. So data breaches, the healthcare system is seen as the most targeted by attackers. It is easy to get medical health information, social security numbers, and like other biometric data that can put the patient at risk. And then the healthcare field is also with telehealth and other health apps, there is low regulation. So they see that as a precursor issue to utilizing this field and this, or utilizing this system. Next slide, please. Then, so the next steps is all the information is in the slides. This was just given on July 30th. We will continue to monitor the progress of this and update as it goes on. Thank you.
And Ariana, thank you. As I'm sure the audience can appreciate, this is a significant set of developments, and tracking them closely as they move forward will be important, not only for patients generally across the country in whatever way they access the healthcare system, but many of our clients are healthcare delivery organizations and others, and staying on top of what this means for them is something that we commit ourselves to doing for all of you. And of course, there are these really interesting overlays between the cybersecurity and data privacy aspects of the proposal and the healthcare in the main aspects. And it's one of those issues, certainly, that in our practice group, where I'm a member in health and long-term care, that we're going to be watching very closely as well. So Ariana, again, thank you. So glad you could take this time on the program. Please come back on when there are more developments in this space. We want to make sure that we're staying on top of them. And what I'll do now is shift to our next speaker for the afternoon. Thank you again, Ariana. And that's Greg Katz. Greg is with us from the New York City office. Greg, as I mentioned, was on 2 weeks ago. Here, Greg is going to cover some distinct ground, private equity relating order out of the Trump administration. One fun fact, as it were, about Greg is that, at one point in his career before arriving at Bond, he was detailed to the House Ways and Means Committee, which I'm sure was highly informative and certainly gives insight, on a daily basis. As someone myself who once worked in government, it is always useful to have that background under your belt. And so, Greg, glad again that you can be on the program. Welcome back.
Thank you, Gabe. Okay, so let's go ahead and talk about this executive order. So first, let's go and do a little bit of background. If you sponsor a defined contribution plan that's a 401k, a 403b. There are some others in there, right? Your decision to offer a certain type of investment, um, an investment alternative for your participants to put their money into is subject to fiduciary duties. The chief one I'll talk about is the duty of prudence, and you have a duty to prudently select and monitor those investment alternatives. So when you're choosing them, you have to look at the expense ratio and past performance, and you have to monitor them to see if they're doing what you expect and whether you're paying too much compared to other investment options. So, against that background, let's go to the first Trump administration. That's in 2020. The Department of Labor, the US Department of Labor, issued a letter providing guidance on selecting investment alternatives that featured private equity, right? The letter said a planned fiduciary of an individual account plan, now that's a 401k or 403b or some others, may offer an asset allocation fund with a private equity component. But the letter hedged, right? It said, however, it also noted important fiduciary concerns with doing that. It noted the expense and the complexity of that. So that's where things stood until 2021. And then now this is the Biden administration, and they issued what they called a supplement statement to the letter, which to me was kind of funny because I had never heard of a supplement statement before. But what it said was they issued it to ensure that plan fiduciaries don't expose participants and beneficiaries to unwarranted risks of private equity. They highlighted fees, complexity, risks of conflicts of interest, that kind of thing. So between the two of those pieces of guidance, you don't see private equity in defined contribution plans today. The risk is under current law and this guidance and the risk of lawsuits, the risk is really the balance of the risk is really too high. And going back to lawsuits, the chief enforcement mechanism for these fiduciary duties, it's generally participant lawsuits for breach of fiduciary duty. And you've probably heard a lot about that. They've been very, very common for the past, well, for a long time now, 15, 20 years. So, the risk of there's nothing in ERISA that says no, you can't have private equity, but the risk of those lawsuits was probably too high. So now let's move on to this Trump administration. And on August 7th, 2025, there was an executive order on private equity and other alternative assets. And basically the stated policy is that the administration wants to put defined contribution plan investors, those are the participants in the plans, on the same footing as defined benefit plans and government retirement plans that do have access to these different classes of investments. And you'll notice that I said something about alternative assets, right? Not just private equity, because the order deals with a whole host of alternative assets in addition to private equity. So these include cryptocurrency, real estate, commodities, infrastructure financing, and pooled longevity risk sharing, which is actually a really interesting concept for another day. So what I found was interesting about the list of alternative assets is it actually de-emphasized the cryptocurrency aspect of it that kind of got a little bit of press. Um, what it said, it referred to actively managed investment vehicles that hold cryptocurrencies rather than the currencies themselves. So, it seems to be placing less of an emphasis and more indirection with respect to that. So, what action did the order actually take? It didn't simply say that planned fiduciaries can start offering these investments, without fear of consequence, and nor could it, because the fiduciary duty framework that we discussed before, um, is based in the statute, and an executive order can't really change that. What it did do was take a two-pronged approach to sort of attempt to adjust the balance of risk with offering these investments in defined contribution plans. One, it directed the agencies to review all currently issued guidance with respect to fiduciary duties. Right, so that includes Department of Labor, Treasury Department, Securities and Exchange Commission, and it told them to review current guidance, and in particular, it instructed the Department of Labor to look at that supplement statement that I mentioned before. So, true to form, about 3 days later, the Department of Labor revoked that supplement statement. So that's kind of one barrier that's already gone. So second, the order instructed the Secretary of Labor to clarify the fiduciary process used to offer alternative assets in retirement plans. So in other words, the order is telling the Secretary of Labor, tell plan sponsors what they need to do, how they need to decide whether to offer these types of assets. And it also told the Department of Labor to propose new rules or guidance on fiduciary duties owed to plan participants. So yeah, you heard that right. That's another fiduciary rule. So I'm sure it'll face some of the same challenges that the previous three did. Okay, so the order instructed the secretary to prioritize actions that would reduce litigation constraining plan fiduciaries. So again, that's kind of like the second prong, right? The first prong is regulation. The second prong is to try and reduce some of the litigation risks that participants can come after plan fiduciaries in how they select their investments. So the order also had a few words for the Securities and Exchange Commission. To the extent that Securities and Exchange Commission rules are standing in the way, things like accredited investor rules and qualified purchaser status rules, the order also directed them to review their regulations. So, takeaways. Okay, so the order walks a fine line between sort of taking actions to allow 401ks and 403bs to offer these types of investments to their participants, and also the constraints of ERISA's statutory fiduciary framework, and the political risk of exposing participants um to too much risk, right? Nobody wants to be responsible for participants losing their entire savings in risky investments. So it's going to take time for agencies to issue guidance, right? If they go the traditional notice and comment route, it'll take a decent amount of time. the order has an 180-day deadline to issue guidance for the Secretary of Labor, but the reality is any final rule is just going to take longer than that. Another takeaway is that nothing in the order requires plan sponsors to offer these types of investments, right? So if you don't want to dabble into, cryptocurrency and private equity and infrastructure investments and real estates in your plan, you don't have to, right? You could imagine a future where these types of investments are common in defined contribution plans, right? And, you could imagine a situation where participants are claiming, well, you didn't offer me these investments and you didn't make a prudent decision, right? You didn't have your prudent you didn't meet your duty of prudence in deciding not to offer them, but that to me, I think that's a long way off. So and it would depend on these investments really having better performance than traditional assets. So now imagine, am I going long here?
Oh, sorry, I didn't mean to startle you, Greg, but yes, if you
Yeah.
could wind up in the next minute or so, we'll move to our next presenter. But please conclude your thought. Thank you.
Yep. Okay. So the other thing I will say, if you want to start looking into this, you're going to want to consider building relationships with advisors that can start helping you evaluate what type of investments for your plan to offer. And with that, I think I will cede the floor and let the next presenter get on with it.
Thank you so much, Greg. And I know there was a lot of information in that presentation. Audience members certainly should reach out to you if they have additional questions. There's Greg's contact information. We'll have it up again at the end of today's presentation. Greg, there's a question in the chat. So there are folks who are still interested in hearing from you. So kindly take a look at that. And now let's introduce Michelle as our last speaker for today's program. Michelle is with us from Albany, as I mentioned, and has a varied and very interesting, as far as I'm concerned, practice, and I think interesting as a benefit to all of you, practice that includes some focus on energy. And I ran what Michelle is going to be talking about past her, wondering if it was right for the webinar, and she said yes, and she was happy to bring all of you up to speed. So Michelle, thank you for taking this time, and I look forward to learning.
Yeah, thanks for having me again. So electrification is coming to new construction in New York beginning January 1, 2026. So not that much farther in the future here. This All Electric Buildings Act was originally passed in 2023, but it's been discussed by the Public Service Commission and the State Building Code Council for the last few years in terms of the right approach for implementation, and it was finally approved recently and is ready to be rolled out. So what that means is that all new construction of single-family residences and low-rise commercial and industrial buildings in New York will have to be outfitted with electrical appliances. That restriction is for buildings that are less than or equal to 7 stories in height, or any commercial or industrial buildings that are less than 100,000 square feet. So if your building is above that, then you don't have to comply quite yet. For existing buildings, you don't have to go and retrofit your buildings to add electrical appliances. You can continue to use natural gas and other fossil fuel equipment that's currently in place. That includes replacing that equipment as needed, or updating that equipment as needed. And this is really just at this time restricted to new buildings that are being constructed. And there's even some exemptions to that, which I'll get into in a second. For buildings that are currently in process, I would encourage you to get your building permit applications in as quickly as possible before the end of the year, if you can make that happen, because the restrictions will not apply to any projects that have a substantially complete building permit application as of December 31st. Also for those existing buildings, if you have to repair, alter, add, relocate, or you decide to change the occupancy or use of the building, you are still able to continue to use existing natural gas and fossil fuel facilities. You don't have to, then go back and retrofit to add electric. So that, that doesn't apply to those types of expansions or anything of that nature. And then beginning in 2029, the limited restrictions will be lifted, and this will pretty much apply to all buildings starting in January 1 of 2029, with certain limited exceptions. Those exceptions, as I referred to earlier, include certain critical infrastructure like backup and standby power, hospitals or other medical facilities, emergency management facilities, wastewater treatment facilities, things along those lines. There are also some other specific types of uses that are exempted, like manufacturing, commercial food, car washes and laundromats and that type of thing. And then even if you have an exemption, the exemption must be limited to the fullest extent feasible. So you can't just claim that you have an exemption and apply it to the entire building if really the critical infrastructure is limited to certain equipment within the building. And you still have to minimize your fossil fuel emissions that come from any exempted equipment. And then there will be a constant review of the exemptions and these rules going forward. So there may be situations where the exemption that you thought you might had can change in the future. So that's really the update for now. The Public Service Commission is currently considering a white paper on implementation of these rules as well. So there may be some further rules that come out associated with the act, and then we may see some further updates in the next few years as we get closer to that 2029 deadline when all buildings have to comply.
I am here, just trying to come back on camera. There we are. And Michelle, thank you so much for that update. It was very helpful to get a snapshot as to where we are in the course of this implementation. January 26th, as you pointed out, is really not far from now. So I encourage any of you that's involved in building processes, you have questions about whether you're carved in or carved out among those exceptions, if you've got to hustle in materials and applications, etc., just to reach out to the bond attorney with whom you work most closely and comfortably. And with that, we're at the end of today's formal remarks, and I wanted to make sure that if Kathy, you could go to the next slide, please. I appreciate it. You have everyone's contact information. There it is. And what I'll also let you know is that Carrie will be your host for our last broadcast in August, a week from today. I'll be with you right after Labor Day on the 2nd. I'm hopeful that all of you enjoy a restful and restorative, if not reflective as well, Labor Day. And wishing you, a good start as well if you are moving into the fall, not officially, but with family and other obligations as we flip the calendar into September. With that, wishing everybody a great afternoon.